opportunity to argue today. Thank you.
Thank you both. Next case on the docket is DeLong versus Lakeview Loan Servicing.
May it please the court, I would like to reserve 5 minutes of my time for rebuttal. My name is Donato Rinaldi. I represent Mr. DeLong in this appeal. I also represented Mr. DeLong at the trial. This case is before the court on a mortgage foreclosure. At the trial judge entered judgment in favor of the lender, and we appealed, asserting 3 errors. I would first like to speak to the... No, Your Honor. I would actually like to speak to the failure of condition precedent. This
Being the notice and the language that has to go to it because it's a VA loan.
Yes, Your Honor. This loan was a VA loan, and because it was a VA loan, it's governed by the regulations promulgated by the Department of Veteran Affairs, the VA. The note incorporates in paragraph 12 those regulations. The mortgage on page 2 has a VA rider box that's checked, which indicates that it's a VA loan, and the rider itself incorporates the regulations into the mortgage. So there's no doubt that the VA regulations apply.
So when does the notice have to be given?
Yes, Your Honor. According to the regulations, it's supposed to be given no later than the 82nd day following default. And the way we arrive at that is once the loan is in default for 75 days, that's supposed to trigger a letter to be promulgated within the following 7 days.
Does it have to be sent within that time frame from the initial default or from any default?
The default that the lender wants to act on. The only default at issue was the default from December 1, 2012.
Was the allegation that your client failed to make the payment in December and any subsequent payments?
I believe that was the allegation, Your Honor, yes.
Therefore, there was another default every month, correct? Under the allegations were that there was a default for the month of December and for every month thereafter, correct?
Yes, Your Honor.
Okay.
However,
So did the notice have to be sent within 82 days of the first default or within 82 days of some default?
the regulation does not say specifically, does not speak to subsequent default. It says from the date of default. The reason why is the regulations are promulgated to nip these things in the bud, to act sooner rather than later. So it would not make sense, it would not be consistent for the VA regs to allow something to cook it and get unwieldy, and then at some time later, let's try to address it. That's not the purpose of the regulation.
We accepted your argument and dismissed this lawsuit. Could the lender refile the lawsuit, or are you saying that the whole debt goes away because they didn't send a notice within 82 days of the first time there was a default?
Unfortunately, I concede that Lakeview would probably be able to sue again, provided that it sends a notice on a subsequent default within 82 days. The problem here is the regulations say 82 days from the default. The act of default was back in 2012.
Okay, so if they file a new lawsuit, can they seek the entire unpaid balance on the mortgage, or have they lost some of the earlier payments because of the delay?
I think any payments, any installments that are greater than 5 years old would not be recoverable because of the statute of limitations. Each individual installment is like its own contract, and 5 years from that date goes forward. But I think
Well,
if-
hasn't the Supreme Court said in the statute of limitations context that if you refile, you can in fact get the entire debt, even payments that are more than 5 years in default?
I don't know that that's the language that it uses. It says that you can recover past defaults as long as the default you're alleging is within the 5 years. And the recent language has come out with Bollettieri and others that the subsequent.
Well, let's say then, okay, if we reverse and dismiss the lawsuit, and Lakeview says, okay, we'll start over, and they actually send a letter, provide a copy of it to you in discovery that complies with the VA regs, and says, okay, we're going to pick the day of let's pick it within 5 years, March 1, 2014. They pick that date, and they send a letter saying you're in default as of March 1, 2014. Well, that's clearly more than 82 days later than March 1. So how do these things interface with each other? What happens?
Well, I think that the problem here is we have a state statute of limitations that says one thing, and I understand that. But we also have a statute that says the lender is supposed to do X. And if the lender doesn't do X, too bad on the lender. The lender...
Following up my scenario then, essentially what Lakeview would have to do, assuming you get the relief you're requesting, is they'd have to go back and say, okay, assuming that your client hasn't paid anything, as of July 1, 2017, you're in default. Let's say they send this letter August 1, 2017.
Yes, sir.
Okay, so then essentially from December 1, 2012 until July 1, 2017, those payments are gone. They have no ability to recover them in a foreclosure is what you're saying.
I'm not sure, but I think that is the way I would lean, because the federal regulations specifically state you have to send this letter within 82 days of the default, and they didn't. So the lender, the federal government did not hold a gun to the lender's head and said, give VA loans.
I mean, Judge Palmer's referring to the Bartram case. So if it's a July 1, 2011 or July 1, 2012 default date, that case goes away in favor of the defendant. Then the next month, on August 1, 2012, assuming they file within 5 years, and we get past the continuing default issue, but let's say it's timely just on its face for the default. Bartram, as we understand it, you can collect, because it's unaccelerated and now it's become accelerated again, so you could still collect what's not been paid, which is just a mathematical computation. You seem to be saying under the regs here that can't really happen because there's an 82-day time frame for any default. And if if you try to go back to lawsuit number 2 and you're past 82 days, you can't do that because your letter will be violative of the regs. That's what you're saying, I think.
That is what I'm saying, Your Honor. Actually, it is.
Let me take it one step further then. Does that mean if we were to dismiss this lawsuit, that your client could then start making his payments, just his regular monthly payment, no
Absolutely.
arrearage, and there would be no foreclosure, and all of the debt up till the date that he started to repay the mortgage would be forgiven?
Absolutely. Because we're not dealing with just a strictly Bartram situation. We're dealing with the interplay of Florida statute of limitations, Bartram, and the VA regs, which are incorporated into the contract. Remember, this is part of the contract. They contracted for these terms. Both of these parties were free to contract, and they contracted for this bargain. So they have to live by the bargain, and the bargain is, if there's a default, I need a letter within 82 days. Shame on them for not doing it.
Well, let's take it outside the context of the VA regs for a minute. Under paragraph 22, there's a notice you have to send as a condition precedent. I think Judge Wallace wrote about that in Palma and other things. If that letter is not admitted into evidence, essentially, for whatever reason, and it's not challenged on appeal, is it your view then, in essence, the plaintiff hasn't proved its case because one of the elements is not there?
If it's not challenged on appeal,
Yeah, I mean, I want to admit this into evidence. Defense counsel objects, so it's not admitted into evidence, so there is no other acceleration letter that's in file, and let's just say it's not been waived or
Okay.
things like that, the defendant hasn't...
so the letter is never before the court?
The letter's not been admitted, it may physically exist, here I'm
Right.
looking at it, Judge, and I'm talking about it in closing argument, but it's never been admitted into evidence.
My position is that the lender fails to prove its condition precedent and needs to have an involuntary
If it's failed
dismissal.
to prove it, and forget about, again, the VA is just on the straight
Correct.
paragraph 22 claim.
Correct, just on the paragraph 22, because my understanding is that this letter is kind of doing double duty,
I
acting
mean, your
as,
position in this case, and then, circling back to your case, is there is a letter, I mean, you talk about, well, we didn't have a face-to-face meeting, it's grossly
Right.
late, and, but at the end of the day, the letter was not admitted into evidence.
that is correct.
Because if I understood it, you objected to it because they objected to producing it in discovery, and in fact, when they replied to your affirmative defenses, they sent you a copy of the paragraph 22 letter and did not provide
Correct.
this letter. So you were at trial saying, they didn't send it, Judge. They can't, they can't have their cake and eat it too and put this into evidence now. And the judge agreed with you.
Yes,
So in essence, if these VA regs are are a condition precedent, then they have not complied at all with that requirement to bring a foreclosure action. No different than if the paragraph 22 letter was either never sent, or if sent, was not admitted into evidence.
that is exactly...
That's your argument.
That is my argument, that is essentially the same thing, that if this was not a VA loan, and it was a standard paragraph 22 argument, and I'm not arguing that they sent the letter, but it only gave them 28 days or 29 days, and that's substantially compliant. We're arguing that it was never sent at all, so prejudice doesn't even come into play, never sent, no compliance at all, involuntary
Not
dismissal.
an issue of substantial compliance or whether there's prejudice
Right.
when there's substantial
It's no compliance.
Because if you just simply don't send the letter saying, I just didn't bother with sending these letters, we waste a lot of time sending these letters, they don't matter anyways, because these borrowers never pay up anyways, who cares? We'll save ourselves, millions of dollars of postage throughout the country. We're just going to do this.
Well, that would be my position, that if they don't send a letter, whether it's the
send a letter,
paragraph 22 or this, they can't.
Win on that claim and that cause of action.
That is correct. That is,
We then smarten up and send it.
that is our position, Your Honor.
And your position then, as I understand it, is this is not an issue of an untimely notice in this particular case. It is an issue of no notice.
It is both, because,
How could it be untimely notice if no letter went into evidence to show when any notice was given?
if Your Honors determine that the trial court was not in error in using the letter and considering the letter, then I need to fall back on,
Is there a clear case law that says you can't base your decision on
yes, sir.
non-evidence? I mean,
Yes,
that's
and
like
I've
saying-
cited it in my brief 2 or 3
I mean,
cases.
Forget about the letter, that's like saying, well, I didn't hear any testimony, but I'm going to rule on this and find that this person said this.
I understand, Your Honor.
If they didn't say it, and we look at the record and it's not there, and that's what the judge says, well, I thought he said that, and that's the dispositive issue in the trial.
I believe that the dispositive issue is that there was never a letter entered, it was never properly before the court, and if the trial court considered the contents of that letter, it was improper, absolutely.
Well, he was looking at it at the end. I mean, if you read the transcript,
Yes.
he was looking at the letter, and you guys were having some discussion about whether it was admitted, and I think the opposing counsel said something about rebuttal, that...
Right, but ultimately it was never admitted.
The letter was never admitted into evidence.
And that is part of one of the things we brought up on appeal, is that it should never have been before the court to consider.
Well, but where's, you say no notice, no meeting, correct?
Excuse me, Your
There
Honor?
was no meeting, as well, face-to-face meeting, no attempt to have the
Correct.
face-to-face. So do we stop with no notice and we never get to your issue of there never being any attempt to set up a meeting or a face-to-face meeting?
I would hope so, because I don't think Your Honors reach the merits of the letter itself, because there's no letter to consider. I don't think you reach that issue. I really don't.
Was there any testimony separate and apart from the letter, perhaps as an attempt to give the basis for the letter? Was there testimony that we sent a notice, even if the letter itself didn't go into evidence, or was there no testimonial evidence either for the
I believe Ms. Peichel alluded to the letter, alluded that they had sent notice to Mr.
So
DeLong.
the witness testifies, we sent a notice. Was there a motion to strike, or saying no predicate, or best evidence, or some reason why she can't testify to that unless the letter itself goes into evidence?
I failed to preserve that type of objection, so I did not move to
So
strike.
there is something in the record from which the trial court could find that some letter was sent in September, but maybe not the extent of what the contents of that letter was.
I believe you would be correct, Your Honor, that the trial court heard testimony from Ms. Peichel that some type of correspondence or letter was sent to Mr. DeLong, yes. Yes.
There was two letters of the same date, one of which was actually admitted into evidence, the paragraph 22 letter.
Yes.
Okay, but that's really not the crux of our discussion.
No, it's not.
I know it's the crux of his discussion, because he doesn't think the VA regs, even though they're expressly incorporated into the note and the mortgage, he doesn't think that those are applicable here.
I understand. Your Honor, I've reached my time.
Go ahead, I've got a question and...
Well, go ahead and ask, Your Honor.
If a witness had testified, I sent a notice that complied with the VA regulations, but didn't offer the letter into evidence, and that testimony was not stricken for any reason, would that be sufficient to meet their case? Because you have some evidence of, I sent the notice with the VA requirements in it.
No, because in order for that evidence to be sufficient for a trial judge to rule that they satisfy the condition, there would have to be more testimony than we sent a notice that complied. I believe the witness would have to articulate what the contents of that notice were to show that there was compliance.
Even in the absence of a best evidence sort of objection.
I do believe that, Your Honor.
Okay, thank you.
Thank you.
You've got about 4 minutes left for a rebuttal.
Sit up there.
Good morning, Your Honors. May it please the Court, may it please Counsel, Charles Gufford with McCullough, Raymer, Liebert, and Pierce on behalf of the plaintiff and appellee, Lakeview Loan Servicing.
Do you think this is a no-notice case or a late notice case?
I can argue both positions. I think that although they are strictly construed and implied with the note mortgage, the VA regulations, specifically as we're arguing 36-430-50, it was still complied with. There was a letter submitted into evidence. It was testimony, it was testimony regarding that letter, not the evidence, not the fact that the letter was submitted into
Well, the
evidence.
letter was, I mean, you tried to admit the letter, and it was objected to because you guys didn't produce it before.
Correct.
You know, I mean, and it sounds like the trial judge was eminently correct to say, you know, you can't not produce stuff and then present it at trial. That's just not fair, for lack of a better term.
Understood. No argument against that, Your Honor.
You have no letter that complies, you have no physical document in evidence that complies with the regs.
Correct, Your Honor.
And your note and mortgage specifically adopt these regs, and in fact, saying if there's anything in these documents that are inconsistent with these regs, the regs control. So that trumps paragraph 22.
Correct. No,
Okay,
I know, I'm with you. So the tailored argument against it is they are incorporated. I agree. And obviously this not this panel, but obviously dealt with in the Palma case.
Right there, that's the guy that wrote it.
Your Honor, there was magic language, which I like to refer to this court, which the court's probably well aware of. This note does not authorize acceleration when not permitted by HUD regulations.
Well, let me ask you then, what I asked your opposing counsel. So if this was just a straight paragraph 22 case, and you don't comply with you don't send a paragraph 22 letter, don't you lose the foreclosure?
I do, but that's not the case here, because I don't think, if you look at the regulation, what is the penalty for not complying with that section? Is it you can't foreclose, or is it something else? That's why I'd have the court look at the regulation itself that was cited to not only by opposing counsel but myself, and look at it, and if
I
you
know,
look...
subparagraph 2 of that.
Exactly, and those sanctions under subparagraph 2, Your Honor, are under strictly for suspension, debarment of the servicers on behalf of the VA, and sanctions and fines imposed.
I mean, in essence, it says if you're not gonna play by our VA rules, then maybe you're not gonna be a VA lender type of person anymore, but
Correct.
are they mutually exclusive to say, we incorporate the notice requirements of HUD, of the VA regs into our note, they trump paragraph 22, you've just told me if you don't give a paragraph 22 notice at all, you just decide, we're just, as a matter of policy, we're never gonna send these notices, you lose your foreclosure. How does it not logically then follow?
Because it makes it in not only the Palma case, but in paragraph 22, a condition precedent to foreclosing. It specifically spells that out. It does not spell that out in these regulations before the court.
Paragraph 22, does it?
It does in the mortgage, Your Honor.
Paragraph 22 says if you don't send this notice, you can't accelerate?
Well, it's a condition before accelerating itself, meaning we must give this notice. That is not contained in the regs, that you must give this notice to accelerate or foreclose, which is different.
These are a minimum, these collection procedures must include, you must do these things before you, as a part of your collection procedure.
Collection procedures, Your Honor, but it doesn't
The
say...
foreclosure.
But collection
No,
procedure...
it's
but it-
not a collection, foreclosure is not a collection procedure.
It's a collection procedure that, and in the essence of talking to borrowers, doing what you need to do, but it doesn't, I don't think, amount specifically to the point of incorporating in the note and mortgage saying, your failure to do this results in your inability. Because if you look at the HUD regulations, there is a section that under HUD, which is under 203-500, which is clearly under subpart C for the face-to-face meeting. If you look at it, it is the intent of the department that no mortgagee shall commence foreclosure or acquire title to a property until the requirements of this subpart have been followed. You will not find that in the VA regulations. For lack of a better term, they're not as strict as the HUD regulations. That's where I'm calling the distinction. Yes, they're incorporated. Yes, they should have been followed. They weren't, or at least the evidence at court did not show that. But the fact is it truly a condition precedent before the institution of a foreclosure action? HUD makes it...
It trumps paragraph 22. By the language of the document, it said anything inconsistent with this regarding procedure.
But how is it inconsistent, Your Honor? That's my question. How is paragraph 22 inconsistent with the language in the VA reg? The VA reg says you must do this, this, and this. It doesn't say your failure to do this results in your inability to foreclose. I know it seems like a strict interpretation, but I mean, that's what I'm taking out of it. Yes, sir, you got it. Obviously, I don't understand. Yes,
You
sir.
concede that the trial court, in making its ruling, relied upon a document which it had previously excluded from evidence?
I do not believe that at all, Your Honor. What I believe is that it was an equitable defense asserted by the bar, since it's not a condition precedent.
No, the trial judge said, I find that you've complied with the VA regulations.
But regardless of that, Your Honor, if
Because
it's...
he was looking at the VA regulation letter that was not admitted into evidence.
Understood, but even not considering that,
Forget about
ignoring...
what he said.
Well, let's just think about it. Even if you say that, let's say if it's not a condition precedent, that we didn't have to follow, that it didn't bar the foreclosure.
Well, let's assume it is. So, okay, so now we're...
Well,
let's assume-
if it
let's assume
is-
the majority of the panel disagrees with that. So now it is a condition precedent. He's looking at a letter that he excluded from evidence. He's talking about it, saying, in fact, he said something to the effect, well, looks like all the language from the VA reg is in this letter. I'm paraphrasing it pretty closely, though.
I don't disagree with the court. He should not have relied on that.
Well, he's
I'm not.
looking at it and basically said that, though.
But the point still being is, if it's not a condition precedent,
Okay, but if it is,
But my question was, would you concede that he considered a letter that wasn't in evidence? And your answer could be, yes, but here's why it doesn't matter.
That is
But I
correct, Your
heard
Honor.
Your answer to be, no,
Yes.
I won't concede that.
no,
Let's
it
cut
is,
that
it is.
back.
Let me rephrase. You are correct, Your Honor. Yes, but in the alternative.
So
So I'm not-
the trial court clearly made an error in using that letter after excluding it from testimony.
Correct. If it was not, though, a condition precedent, and
then we
we...
wouldn't be having this discussion. If it was an
Well,
irrelevant piece of paper, then...
I understand, Your Honor. I'd like to at least try to make the argument for the court. that it was just an equitable defense, that the court considered everything else and denied the equitable defense, not only based on the testimony of my client, but on the testimony.
Wasn't how it was raised, though. I mean, your opponent says, there's a statutory obligation that says, and here's the statute, you have to do this, and you've not done this. Not just, well, it's equitable, we're in a court of equity, therefore,
Understood,
what's
but,
right.
but again, if it's not a condition proceeding, it has to be an equitable defense under the Cross case, Your Honor. Going on, Your Honors, I assume issues 1 for standing was sufficiently proven based on the fact that obviously it was a blank endorsed note that was filed with the complaint that matched the one that was filed with the court.
What's your position about what the practical consequences would be if we were to accept the appellant's argument and dismiss this lawsuit? Do you get to start again? And if you get to start again, do you get to seek the entire amount of the debt, or are you somehow limited as to how much of the debt you can collect?
So if the court does dismiss the case, we can refile. We must allege a breach date that's within 5 years, and we can collect the full amount due.
And so your demand letter, which you're the nip it in the bud argument, the purpose of the VA, the original letter in default can say, okay, you defaulted, you didn't make the payment 3 months ago, 6 months ago, whatever, and to cure it, you got to pay however many years you're in default.
That is correct, Your Honor.
Beyond the 5 years.
Beyond the 5 years, because the issue is it's a procedural bar for filing, not an elimination of the debt, because I don't think the court wants to go into and start construing contractual terms due to the fact that we also have the promise in paragraph E of the mortgage, which is his promise to pay the entirety of the debt when it fully matures. You also have that in paragraph D of the note, no waiver of the note holder for failure to collect that. You still collect the full amount of the debt. And even under paragraph 12 of the mortgage, you have no forbearance by the lender based on a waiver.
So if they wanted to, upon the dismissal of this lawsuit, if they paid you the last 5 years of missed payments, then they're home free, they're not in default.
I'm sorry, could you repeat the question? I wasn't.
If we were to dismiss this lawsuit and they tendered you a check for the last 5 years of payments, let's say they were 7 years in arrear at that point, then you couldn't foreclose because there's no default within the last 5 years for statute of limitations.
No, sir. I would say, yeah, there's no default within the 5 years, but you still have the existing amount. And I don't know how you would actually treat that, because obviously it may have been based on a default date that you can't collect on in the sense of filing procedurally, but it's still amount that's still owed under the note and mortgage. So I don't know if you would put that on the new default date and say, you're defaulted on this date, you owe this amount of money based on the arrearage. I guess that would depend on the terms of the note and mortgage and how you would re-breach them based on that amount that's beyond 5 years that you can still collect on, but can't rely on that old stale breach date that's beyond 5 years. Your Honors, if there's no more questions, I would...
If there's no evidence that this VA letter was sent, I mean, we know it's been excluded. If your witness, can't remember what the witness is, Ms. Pickle or Pickle?
Yes, sir.
If she doesn't testify about this VA letter at all, and she talks about the 30-day letter or the, paragraph 22, if there's no other testimony about, well, I sent it and it complied, and if we disagree with you about it being a condition proceeding, if we think it is, it's enforceable, you disagree, but obviously you're trying to convince us, we're not trying to convince you. In essence, then, if there's no letter, then there's been no compliance with that condition proceeding, and it should be dismissed.
Correct. If there's no testimony coupled with no letter,
Right.
then yes.
Well,
But
clearly, there's no letter.
There's no letter, but we do have testimony.
But
You're right.
if there's testimony about the default letter, the 30-day letter, and there's testimony when your client, your witness is being asked, well, yeah, you've got all these other letters, but they don't have any of the 82-day language or any of the other stuff in these letters, and your client, Ms. Picker, your witness says, no, you're right, they're not in there, if that's what the transcript says, and we don't talk about the actual, this letter, then in essence, if we decide it's a condition proceeding, then you should lose and have to start over.
That's correct, Your Honor.
Okay, but your position is that there is testimony that says, we sent this letter, it complied with all the language, And arguably, like, you know, you're looking at the letter itself, I know it's part of our record, it's not admitted into evidence. It does comply.
Correct.
It's just not admitted.
Correct, Your Honor.
So the issue then is, what's the effect of that vis-à-vis whether it's a condition proceeding? And is there anything else that's in the record that would support the judge's finding that the VA reg was complied with?
Other than the fact that if you continue to look at the VA reg, the intention of the reg is not only to comply
I know,
with that, but,
we've already,
you know, it's to
I understand
support
your-
communication. And obviously, based on the testimony of the defendant and the plaintiff,
but
there was that
doesn't-
going
I mean,
on.
You could, forget, again, taking outside of a VA loan, if it's a paragraph 22 letter, the fact that there's been conversations back and forth between the borrower and the lender that don't come to fruition pre-suit, if you don't send that paragraph 22 letter at all and there's no evidence about it, the fact
You're
that
done.
the fact that you've had discussions about, well, I'm trying to save my house, what can we do, do you got any programs, that becomes evidence, but that doesn't trump the fact that there is no compliance at all with the paragraph 22 letter.
That is correct, Your Honor.
Well, but if there's testimony but not the underlying document, then you still have the timeliness argument about the notice, right?
That is correct, and that it was sent,
Notice being
and that
sent in
we did
September.
comply.
So, is it your position that a notice sent in September after a December default is somehow timely or adequate, and if so, why?
Correct, because it was substantial compliance, obviously based on the Gorel
Well, Gorel
argument.
the Gorel, I think I was on that panel.
Correct, Your Honor.
You know, you're supposed to send it on 30 days, it was sent on 29 days, and then the fuss in that case was, okay, why did that day make a difference? You know,
And that's what I was getting to with the
I
court.
understand the substantial compliance, but I mean, isn't it kind of hard to say, we missed the deadline by 208 days or whatever it is, and that's still substantial compliance? When does it become non-substantial compliance? 308 days or what? Is that-
I guess when you never did it,
Trial judge
obviously.
decides and we review it?
I don't know the answer to that question, Your Honor, but
Well, in this case, unlike the typical case, which is you couldn't show that if you'd given me the notice on the 29th day, I would have paid up, for example.
correct.
Here you have this argument that they characterize as a mitigation of damage argument, but may also be a materiality argument, which is they had some evidence that they were able to get funds through this program, and if the notice had been given earlier, then there would have been less money due, and they would have had enough money to bring the mortgage current.
Possibly, Your Honor, but that also ignores the fact that bringing it current and giving an offer is different. Obviously, paying a reinstatement amount is what you're supposed to do under a note and mortgage terms of the contract, not offer something that may have been less than was actually owed under the note and mortgage.
But in substantial compliance, though, I mean, if it was sent within the 82 days, he'd have been a couple grand behind. Like, it was a payment like $1,000 a month, somewhere in that area. And by stretching it, by it being stretched out to September 17, when, okay, here's the drop dead letter saying, you know, fish or cut bait letters, better legal term, but use it. All right, you know, now it's to a point of unwieldiness for him. He can't get that kind of money together, and that's the prejudice in comparison to Gorel, when, you know, what would the magic day have done a different to you if we send it on the 30th day as opposed to 29th? You know, he has a better argument, the homeowner has a better argument to say, you know, you waited 8 more months. You know, it's not like you sent it a day early and I'm complaining about you sent it on day 29 instead of day 30.
Yeah, but that's also ignoring the fact that he's ignorant of the fact that he's in a state of default, that he's already received letters that were in evidence that showed him he was in default and he knew it. And he could just have easily gotten a reinstatement letter from the lender and reinstated it based on that $14,000 that he was given or offered.
But your client could have easily moved within short of the 5 years when he originally went into default, correct? It's clearly set out in the contract. You chose not to do that, wait beyond the 5 years, and that was part of your agreement, correct?
I'm sorry, Judge Wallace, could you restate that? I'm sorry.
You said that clearly he knew that he was in default in whatever time frame it was. However, you knew, or your client should have known, that within the 5 years that you didn't move for default, that he was in default, correct?
Well, his default date was in December 1st, 2012. We didn't file the foreclosure until 2014. So there's about a 2-year period. And if you look at the letters, there's letters going back and forth and that are in evidence where they're trying to work stuff out, trying to put them on notice of the default.
Well, following up that, I mean, he actually had some issues before December 1, 2012 that he kind of worked out. I mean, he got current or whatever. And there's letters after December 1, but I mean, there's a December 26, 2012 letter that's in evidence that talks about I think M&T or whoever sent the letter saying, you know, we've heard about that there's some damage to your property and you might have got some insurance money, so what's up with that?
Correct.
But that's not oh, by the way, you're in default, and how about, can you
Correct,
work
but
it out? I mean,
I'm not talking about that letter, you're
Okay,
correct,
but
Your Honor.
that's kind of...
But there are other letters.
That's ironic in the sense that he's in default, the VA regs require prompt action, and M&T or Lakeview or whomever, I can't remember who sent the letter, is saying, hey, what happened to your house? What's going on with the insurance money?
Well, that's ignoring the fact, which we know we can't consider the letter because it's not in evidence, but it was sent. So arguably, they did comply, and they're sending this letter in addition to say, if you have an insurance claim, as the lender on your mortgage, we're entitled to make sure that those proceeds are put towards the home to fix the property.
I think these earlier letters kind of go to negate his argument you didn't have a face-to-face meeting. I think a face-to-face meeting under the regs is only required once, they've made contact, you're trying to work it out. And
That's correct.
There's certainly evidence that they've made contact. The face-to-face meeting, as I read the regs, is only if you can't get a hold of this person, and so you finally make efforts, let's have a face-to-face meeting. So I don't think much of his argument that there's been no face-to-face meeting, because I think there's evidence that the trial judge could have construed that said, they are communicating in some fashion about loss mitigation or what have you.
Correct, which is under paragraph 3 of the court cites, that's correct.
Right.
Your Honors, I didn't know if there's any other issues that I may broach before the court. If not, we'd ask that you affirm the lower court's judgment on appeal. Thank you.
Your Honors, I would just like to briefly touch on a few things. First of all, opposing counsel talked about PAMA. PAMA basically says HUD regulations, they're incorporated into the note, they're incorporated in the mortgage, it's a condition precedent. It's that simple.
But that language in the HUD, it says you can't accelerate unless you comply with these things, and that's actually not verbatim in your VA reg note.
That is correct. That language is not in the VA regs. However, if you read the VA regs, it is apparent the purpose of these regulations, which is keep the veteran in the home at all costs. The regs do say that. The last thing the VA wants is for a veteran to be to be homeless. And so that the servicer, as part of its servicing for a VA loan, is supposed to do everything within its power to keep the veteran in the home. So if they don't do everything within their power, then they haven't satisfied the regulations. Those regulations are incorporated into the note and into the mortgage. And so, by analogy with PAMA, it's the same thing. This note, this mortgage incorporated into the terms, the VA regulations. And so the plaintiff, the lender, was bound by those terms. Opposing counsel also was saying that, it doesn't matter to a degree because these were equitable arguments, and if you look at paragraph E and paragraph 12, they say that we don't waive our rights and everything like that. It's true, the note and the mortgage do say those things, but the VA regulations, the rider, states that anything that contradicts or not in keeping with the VA regs, that's amended to make it conform to the VA regs. So anything in the note or in the mortgage that might be construed as not a waiver or not a requirement, that's not to be read that way anymore, because the VA regs specifically say this overrides whatever's in the note and whatever's in the mortgage that is contrary and not consistent with the VA regs. So the note and the mortgage are basically amended there too.
So do you interpret this note and mortgage to mean that a lender or a holder does not have to send the 30-day notice under paragraph 22 because there's a different notice requirement under the VA regs?
No, because you can read those together and not reach a contradictory solution. You can send your paragraph 22 letter within 30 days, and that doesn't do any violence to the VA regs, but you also have to comply with the VA regs. If, however,
You send a 30-day notice letter, what's the point? I mean, what is the point of it? I mean, if the VA regs supersede them or trump them according to the documents, what's the point of sending the 30-day notice letter?
because the VA is looking to protect the homeowner veteran, and so it's an added protection. It's almost like a belt and suspenders kind of approach. If you look at the notes and the mortgages for FHA, there is no paragraph 22, or paragraph 21, or paragraph 17, whatever version of the note. There is no version of paragraph 22 in those FHA loans. In here, it's there, and as long as it doesn't contradict with the VA regulations, they have to perform the conditions preceding under paragraph 22, as well as whatever is required by the VA regulations.
Thank you, counsel, your time's expired.
Thank you, Your Honors.